Since the preamble is a very important part of the Indian Constitution, the interpretation of the preamble is also included in the interpretation of statute syllabus. But we don't need to cover this in depth. And also, whatever I'm discussing here today is already covered in the constitutional law series. First of all, an interesting fact about the preamble is that though it is at the beginning of the Constitution, it was adopted after the rest of the Constitution was drafted. One of the first questions that arose about the preamble was whether it is a part of the Constitution or not. In the Berubari Union case in 1960, the Supreme Court held that the preamble is not a part of the Constitution as such, so it is not so important. Later, in the Kesavananda Bharti case in 1973, the court reversed its view and held that the preamble is as much a part of the Constitution as any other provision or article. The Constitution is the supreme law and the supreme rule book of the country. So, can the Constitution be amended? Of course, the Constitution can and should be amended because it is a living document which has to change and adapt to the social, economic, cultural, political and technological changes in the Indian society. And so far, the Constitution has actually been amended more than 100 times. But if the Constitution defines what India is as a country, the basic idea about what we are, can the Constitution be changed indiscriminately? Well, the answer here is no. There are some limits to the changes that can be made to the Constitution. In the Kesavananda Bharti case, the court held that the objectives mentioned in the preamble are part of the basic structure of the Constitution and may not be amended, which means that the Constitution can be amended, yes, but no amendments can be made to remove the objectives mentioned in the preamble. For example, the preamble mentions that we are a democratic republic, and no government or parliament can change it to say that we will now be a communist republic. And the fundamental features of justice, liberty, equality and fraternity that are mentioned in the preamble are sacrosanct, and all statutes, laws, rules and guidelines in the country must adhere to these fundamental features. And also, the actions of the government and the citizens must not contravene these basic requirements. These basic requirements have been called the basic structure of the Constitution, and the basic structure doctrine just means that the Parliament can amend any part of the Constitution, but the basic structure must not be altered. So, does it mean that the preamble cannot be altered at all? Well, it can be altered, and it has actually been altered at least once so far, in 1976. This was when the words socialist and secular were added here, and the word integrity was added here. So, if the preamble is a part of the basic structure, and the basic structure cannot be changed, then how come these changes in 1976 were not challenged? Well, I believe that it was because these changes are not negative. That is, they do not take away anything from the existing basic structure, but they only add more clarity to it. So, these changes were probably never challenged.